Peace, peace, y'all. Welcome back. Welcome back. It's your boys, Vinny L, Vinny the Moor, V Kid. I'm known by many things. Today I had a really interesting presentation for y'all today. I have some PDF files that I wanted to share. We're gonna go through with another crucial breakdown. All right, I got a few of them. First one here. Income tax is voluntary. As you see, this was written in 2003. All right, we're going to go into income tax, just talk about some little things. I know we talked about income tax here before, about voluntary participation in the income tax in the IRS. We also have another one here. It's called the zip code. Use invokes federal jurisdiction. Okay, use of the zip code is voluntary. We're going to go into that on how the zip code, could be putting you under certain jurisdictions and can be used as a way to make you into a corporate citizen. But we'll read more into that in a sec. I have here a guide to preparing your affidavit. All right. If you're representing yourself in the Supreme Court of BC, this is British Columbia. This is from Vancouver. It's from Canada. It will help you prepare for your affidavit. Understand, law is universal, guys. So, don't be afraid to go to other countries to look for the information. Some of the funny thing is, doing a lot of this research, you'll find that most of the information trying to break down this information is usually found in foreign jurisdictions. India has been a very, very useful source. A lot of YouTube videos, a lot of slide shares, a lot of information from India. So we'll also be going into a guide to preparing your affidavit. Remember, your affidavit stands as truth. This word is huge. We'll go into it. I also have one more thing. This book, page 52. This is Legal Fictions by Lionel Fuller. Legal Fictions. I think that's self-explanatory. But in this, I had a few things I wanted to highlight and talk to y'all with about fiction. So first, let's go to that voluntary income tax. I know we talked about this before, but they do have some new information I wanted to share with everybody. Okay, here it is. Income tax is voluntary. A tax on duties, imposts, and excises is not on the person. That's a capitation tax. Is not on the person engaged in an activity. All right. So understand that when you're being taxed, you're not being taxed personally. All right. Your property is not being taxed. All right. It is not on the income tax on the income or property received from an activity. Okay. All right. A tax on duties, imposts, and excises is not on the person, not on the income or property received from an activity, but is on the activity itself. So what are they saying here? That you're not being taxed for your stuff. You're being taxed because you receive stuff through an act. And it's the act itself that is being taxed. This taxable activity is a privilege that is granted and regulated by the government. The tax rate is imposed on that activity, is determined by the income produced by that activity. The income is just a guideline for determining the amount of tax. The tax is not on the income. The important distinction for an indirect tax is that it is a tax on an activity. It is on something you do. So this tells us right here that income tax, as it's represented, is an indirect tax. You can avoid the tax by not engaging in the activity. What's the activity they're talking about? Okay. These three forms of taxation are referred to as voluntary or privileged taxes because the activity which is taxable is engaged in voluntarily and as a privilege granted by the government. It does not cover it does not cover activities which are exercised by citizens as a natural, constitutionally secured right. That's why it's so important to know the Constitution, because it not only defines who you are, it defines who they are and what they're supposed to be doing. We all know that every single, in case you didn't know, U.S. officials are required to take an oath. An oath. It reads, I, A.B. blank, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true and faith allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I. But it's an oath of office. Okay? This oath of office, let's read the Cornell. An individual, except the president, elected or appointed to an office, I solemnly swear I take this obligation freely, that any mental reservation or purpose of evasion, that I will well and faithfully discharge the duties of the office in which I am about to enter. I will support and defend the Constitution of the United States against all enemies, foreign and domestic. Extremely key that you understand that. You have to know the Constitution. Understand that the Constitution of the United States isn't just referring to one piece of literature. All right. Look, revised in 1992. It was revised in 92. This means it's continually being upgraded to this day. Well, until 1992, excuse me. All right. Understand that the Constitution isn't just the Constitution itself. Let's go to Wikipedia right quick. Before the Constitution, you had the first government, the Continental Congress. It functioned as a provisional government. You also had the Articles of Confederation. The Articles of Confederation and Perpetual Union was the first Constitution of the United States. Interesting. You had a 1787 drafting with different constitutional conventions. You had a Committee of 11. You had committees who had changed the Constitution even at the beginning. But again, if we look at the Constitution of the United States and we read the work in what it's saying, we would understand that it not only talks about itself, okay? It talks about other articles and other documents that were here previously. So let's do a quick Constitution, U.S. Constitution PDF search, just so we can know for sure and we can see for sure. I need us all to know this. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States. All right? Now, you also have, shall be composed of 2 senators, Section 3, Section 4, each house, the senators shall receive a compensation. All bills, the Congress shall have powers. Registration or importation shall not be prohibited. No state shall enter. Here it is. Oh, no, that's not it. That's just Section 10. Article 11, the executive powers is explaining the executive office. This is explaining the judicial office. This is explaining full faith and credit. Right? Article 4. But I'm looking for a specific. Oh, that's. Here it is. Article 9. Excuse me. Article 6. Excuse me. I'm sorry. Article 6. All debts, contracted and engagements. All debts contracted. So this means all contracts and engagements entered into before the adoption of this Constitution. What does that say? That is establishing that this isn't the only Constitution that you have to look at. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. What confederation are they talking about? You got to know the history, guys. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, again, treaties made, past tense, meaning treaties in the past that were already made, or which shall be made under the authority of the United States shall be the supreme law of the land. The judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. Very key. This tells you right here, guys, that there's more to the Constitution than just this document that they have in front of you. All right? Let's go back. Now, this activity, the tax rate is imposed on that activity is determined by the income produced by that activity. The income is just a guideline for determining the amount of tax. The tax is not the income. These three, voluntary, all right, because the activity which is taxable is engaged in voluntarily and as a privilege granted by the government. It does not cover activities which are exercised by citizens as a naturally, constitutionally secured right. Again, back to the Constitution. The Constitution talks about constitutionally secured rights. The income itself is not taxed. It is the activity that produced the income that is taxed. And that activity is always a taxable, privileged activity. For example, a gasoline excise tax is not on the gasoline, it's on the sale of the gasoline. Gasoline is property, not an activity. Property can only be taxed with a direct tax. It is the sale of the gasoline that is taxable, an activity. The amount of the indirect tax is usually passed on to the consumer as the tax is included in the price of the product. An easy way to remember the distinction between direct and indirect taxes is to correlate them to inalienable rights and privileges. Very key. Listen to this. Inalienable rights exercised by an individual can only be taxed directly without a capitation tax or a direct tax apportioned among the states. A capitation tax is on your body, which is your personal property. It is imposed on the state where the people live, not on the people directly. Indirect tax, duties, imposts, and excises are applied to privileges, and they must be taxed uniformly. The tax is not on the people or the property, because these can only be taxed directly through apportionment. Therefore, the tax is called indirect, because it is on a privileged activity such as the manufacture of alcohol. But the tax is indirectly passed on to the people buying the alcohol. Any tax on a company activity is really passed on to the customers. That makes it an indirect tax. Let's keep reading. If the Supreme Court had ruled that the income tax was a direct tax, it would be unconstitutional because it is not apportioned. However, the following case shows that the Supreme Court has ruled that it is an excise tax, which makes it constitutional. The conclusion reached in the Pollock case. If you need to know, it's Bushaber. This is Union Pacific Railroad County, 240 U.S. 1, 16-7, 1916. Quote, the conclusion reached in the Pollock case recognized the fact that taxation on income was, in its nature, an excise, entitled to be enforced as such. An excise tax is not on property, but is on privileges. Man, how do we know these people telling the truth, man? Right? They just talking excise tax. Let's just do a quick Google search. Excise tax are paid when purchases are made on a specific good such as gasoline. Excise taxes are often included in the price of the product. There are also excise taxes on activities such as on wagering or on highway usage by trucks. Do I have to pay income excise tax? Yeah, you do. Especially if you're volunteering. It doesn't say yes or no, but yeah. Any duty on manufactured good, which is levied at the moment of manufacture rather than at sale. Interesting. Before you can be liable for an income tax, you must be exercising a government privilege that is producing income. The question to ask here is, when I receive income, am I receiving it in connection with the exercise of an inalienable right or in connection with the exercise of a government privilege? When you receive income, are you exercising your inalienable rights or are you enacting a government privilege? What is the source of that income? And is there a tax imposed on that source activity? The Internal Revenue Code, IRC, in Section 61 lists items of income from taxable sources. All right. Look, I ain't gonna lie to y'all, man. Internal Revenue Code, Section 61. Gross income defined. We've been here. We've been here. You've seen this. Whatever that source may be, if the items of income are received in connection with the exercise of an inalienable right, then that income can only be taxed with a direct tax, with apportionment among the states. Let's read that again. If the items of income are received in connection with the exercise of an inalienable right, then that income can only be taxed with a direct tax. Only. Income taxes are not a direct tax. We just proved that. If the items of income are received in connection with the exercise of an excise taxed activity, a privilege, then that income can be taxed with an indirect excise tax on the privileged activity that produces the income. Is your income received from the exercise of an inalienable right or from the exercise of a privilege? What is the source? To stack the deck in their favor, the federal government always presumes that your income was received from an excise tax activity unless and until you claim otherwise. You may wonder how you can know if an activity is a government granted privilege. The answer is simple. If a license or certificate is required by law in order to engage in the activity, the activity is essentially a privilege, which is subject to indirect tax. Said another way, the activity would be illegal without the license or certificate issued by the government. So licensees and certificate holders, this is for you. I guess it's not worth a lot unless you're asking for a privilege. Those licenses and certificates aren't worth a lot unless you couldn't do the activity to begin with. With indirect taxes, the assessment of the amount to be paid is made by the individual who, with the government's permission, has engaged in a taxable activity, which is the subject of the tax law. A crucial question we must ask is, labor or the income from labor considered property? Is labor or the income from labor or wages considered property? Or is the receiving of income a taxable activity? Is converting labor to cash a privileged excise taxable activity, or is it an unalienable right? Is labor and cash both something you own, or is it something you do? What about a tax on income received from your labor when your occupation does not require a license? Is labor a privileged taxable activity? Or is labor an inalienable property right that can only be taxed with a direct tax? Again, to the Supreme Court. Y'all know I read fast. I'm going to fly through this real quick. Quote, as in our intercourse with our fellow men, certain principles of morality are assumed to exist without which society would be impossible, so certain inherent rights lie at the foundation of all action, and upon a recognition of them alone can free institutions be maintained. These inherent rights have never been more happily expressed than in the Declaration of Independence, that new even evangel of liberty to the people. We hold these truths to be self-evident. That is so plain that their truth is recognized upon the mere statement that all men are endowed, not by edicts of emperors or decrees of parliament or acts of Congress, but by their creator with certain inalienable rights. That is, rights which cannot be bartered away or given away or taken away except in punishment of crime. And that among these inalienable rights are life, liberty, and the pursuit of happiness. And to secure these, not grant them, but secure them, governments are instituted among men, deriving their just powers from the consent of the governed. Among these inalienable rights, as proclaimed in that great document, is the right of men to pursue their happiness, by which is meant the right to pursue any lawful business or vocation in any manner not inconsistent with the equal rights of others, which may increase their prosperity or develop their faculties so as to give them their highest enjoyment. The common business and callings of life, the ordinary trades and pursuits which are innocuous in themselves and have been followed in all communities from time immemorial, must therefore be free in this country to all alike upon the same conditions. The right to pursue them without let or hindrance, except that which is applied to all persons of the same age, sex, and condition, is a distinguishing privilege of citizens of the United States, and an essential element of their freedom, which they claim as their birthright. it has been well said that the property which every man is his own labor. As it is the original foundation of all other property, so it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing the strength and dexterity in what manner he thinks proper without injury to his neighbor is a plain violation of the most sacred property. Included in the right of personal liberty and the right of private property, partaking of the nature of each, is the right to make contracts for the acquisition of property. Chief among such contracts is that of personal employment, by which labor and other services are exchanged for money or other forms of property. The Supreme Court has just ruled that your labor is your most sacred property, and it is the basis of all other inalienable property rights. Can inalienable rights be taxed as privileges granted by the government? Not legally. Maybe Congress, when they passed the income tax laws, meant labor to be taxed. But remember, Congress cannot legislate away parts of the Constitution. They can only pass laws that are in accordance with the Constitution, because the Constitution is where Congress gets its authority. If Congress could vote out the Constitution, you would have no rights. Congress, the legislative body responsible for writing the tax code, understands that the income tax is really an excise tax. Here's from the Congress. Quote, so the Amendment 16 made it possible to bring investment income within the scope of the general income tax law, but did not change the character of the tax. It is still fundamentally an excise or duty with respect to the privilege of carrying on any activity or owning any property which produces income. The income tax is therefore not a tax on income as such. It's right here, guys. The income tax is therefore not a tax on income as such. It is an excise tax with respect to certain activities and privileges, which is measured by reference to the income they produce. The income is not the subject of the tax. It is the basis for determining the amounts of the tax. So since the income tax is an excise tax on privileged activities, how can it be mandatory unless you engage in privileged activities? According to the Supreme Court, it isn't mandatory. Our system of taxation is based upon voluntary compliance and self-assessment, and not upon restraint or force. So the Supreme Court now is saying that the income tax is voluntary and it is self-assessed. The IRS also knows that the income tax system is voluntary. On page 3 of the 1993 instructions for Form 1040, there is a note from the Commissioner of the IRS indicating that the income tax is voluntary. It says, quote, dear taxpayer, thank you for making this nation's tax system the most effective system of voluntary compliance in the world. How do you volunteer to participate in the income tax? We will see later that by filling out a W-4 form. Bam. This is it right here, guys. This is what should let you know that things are not what they should be. Now, the question is, are you going to sit on your loins, or are you going to actually take the time and the effort to get the proper information so you can make the claim that you need to claim to set yourself free? We're moving on, guys. We're moving on. We know that income tax is voluntary. All right, I'm going to be dropping this in the Israelite group right after this video. Next up, zip code. Zip code. Zip code use invokes federal jurisdiction. Use of the zip code is voluntary. See Domestic Mail Services Regulation Section 122.32. Know how to go. Know how to check it. Got to go to USPS, right? USPS.com, United States Postal Service. What are we talking about here? Elements of addressing. Address elements. All mail not bearing a simplified address must bear a delivery address that contains at least the following elements in this order. Zip code, where required. Zip codes are required on priority mail, express, commercial, first-class mail, first-class package service, commercial, periodicals, USPS marketing mail, package services, and parcel select mail pieces. All mail sent to military addresses within the United States into APO and FPO addresses, official mail, business reply mail, and merchandise return service mail. Unless required above, zip codes may be omitted from single-piece price, first-class mail, including priority mail, first-class package service, retail, USPS retail ground, and pieces bearing a simplified address. You don't got to use zip code. You should also know that the Postal Service cannot discriminate against the non-use of the zip code. The federal government utilizes the zip code to prove that you reside in a federal district of the District of Columbia. This is why the IRS and other government agencies require a zip code when they assert jurisdiction by sending you a letter. They claim that this speeds the mail, but this is a sly and subtle trick. It is also prima facie evidence that you are a subject of Congress and a citizen of the District of Columbia, who is resident in one of the several states. That's something we don't want to be. If you're not clear about this by that point, I mean, clear about that by this point, you do not want to be a subject of Congress. You do not want to be a citizen of the District of Columbia. You do not want to be a resident in one of the several states. All right? What is prima facie evidence? All right? For new folks, who just trying to learn this new law. These are new law terms, I don't assume people know any of these things. I presume I know nothing. Prima facie, based on the first impression, accepted as correct until proven otherwise. That means if they have your zip code on a document, they will look at that document with the zip code on it as accepted until proven otherwise. So until you come back with an affidavit, but we'll get into that. The receipt of the mail with a zip code is one of the requirements for the IRS to have jurisdiction to send you notices. The government cannot bill a citizen of California because he is not within the purview of the municipal laws of the District of Columbia. In fact, the Internal Revenue Service has adopted the zip code areas as internal revenue districts. See the Federal Register, Volume 51, Number 53, Wednesday, March 19, 1986. We have the internet. Let's check it out. Periodical. Let's check it out. Download it as a PDF, right? This is what we're talking about, huh? Wednesday, March 19th. Briefings on how to use the Federal Register, air pollution control, hazardous substances, loan programs, Indians, right? Right? So what are we looking for exactly? Let's go back. Internal revenue districts. Let's look around for these internal revenue districts real fast. Let's see if we can do this really quickly. Internal revenue districts. Let's see. Internal Trade Commission, Internal Department, Interior Department, International Trade Commission, Federal Reserve System, Control Locations, Services, Social Security Administration, State Department, Treasury Department, Environmental Protection, Department of Justice. Well, anyway, as you see, it's a very lengthy document. Let's go back. You must remember that the Postal Service, that periodical was just to show that they adopted the zip code areas as internal revenue districts. I'm going to have to probably do that on some independent research and show y'all that at a later time. You must remember that the Postal Service is a private corporation, a quasi-governmental agency. What? The United States Postal Service is a private corporation? A quasi-governmental agency? What? We need some explanations here, don't we? Let's see. The USPS often is mischaracterized. Postalnews.com. Google is always good for trying to debunk some type of myth. What's the popular belief? Mentions post office would take constitutional amendment to eliminate or privatize. The flip side. Ran a column referring to as a quasi-governmental entity, has been privatized in 1971. The Gallup organization, which was responsible for the poll, refers to the quasi-government in an earlier poll report. A recent story claims that the Postal Service was quasi-privatized in the U.S. decades ago. Most of the quasi-confusion can be traced back to the 1971 Postal Reorganization Act, which eliminated the old Post Office Department, replacing it with the U.S. Postal Service. The act was intended to make the USPS self-financing from its own revenues and to make it an independent, non-political public service. Prior to the PRA, Postal Reorganization Act, postmasters were political appointees. Rates were set by Congress, and the POD had to go through the appropriations process to get the money it needed to operate. The PRA established a board of governors. Sounds like a trust, who are responsible for selecting the PMG and setting policies and budgets. It allowed the USPS to use its revenue to finance its operations without any appropriation process. It set up a separate commission to set postage rates. Okay. So what does it mean? What it didn't do was privatize the postal service in any way, shape, or form. Some in Congress would have favored privatization. Consideration was also given to making the USPS a government-owned corporation, but neither of those things happened. The United States Postal Service shall be operated as a basic and fundamental service provided to the people by the government of the United States. It also defines the USPS as an independent establishment of the executive branch of the government of the United States. Executive orders. Being independent doesn't make the USPS a quasi anything. It simply means it's not part of one of the cabinet departments. Other independent agencies include the CIA and NASA. Again, if you don't know about the postal service in this country, we'll dig into some more. The post office is no longer a full government agency. It is like the Federal Reserve System, the IRS, and the U.S. Marshal Service. They are all outside the restrictions of the federal constitution as private corporations. They are all powerful in their respective areas of responsibility to enforce collection for the federal debt. So if you are using a zip code, you are in effect saying openly and notoriously that you do not live in the state of California, but instead are a resident in the California area of the District of Columbia, a federal district. There are some so-called patriot groups that I consider to be patriots for money. They advocate the use of Title 42 suits, send mail to you with a zip code, and actually do things that place you within the municipal jurisdiction of D.C. You must be aware of the movement towards a one world government through annihilation or elimination of state citizens by use of the so-called 14th Amendment and its related laws. Now, this goes back to a claim, well, not really a claim, a recognized fact that everybody who is born in the United States isn't necessarily born a U.S. citizen. They're born a citizen of their respective states. Now, only when you attach yourself to these adhesion contracts, such as the birth certificate, the social security card, which happens to us before we even know. Once those contracts are made to us, we are made federal citizens. This is through the 14th Amendment. You must be aware of this movement, that one world government movement through annihilation or elimination of state citizens by the use of the so-called 14th Amendment and its related laws. This movement can be halted by the efforts of everyone to return to the status of primary state citizens. By becoming a state citizen and not a citizen of the United States, you can get the federal government off your back and out of your billfold. Speaking for myself, I want the original Constitution for the United States of America put back in force as applied against the federal government and the states restored to their original status as republics. So all you have to do is to study and determine your status, whether you are a slave and a second-class citizen, commonly referred to as a federal citizen, or a sovereign state citizen of California. Remember, guys, a sovereign citizen, that's an oxymoron. Don't fall for that. Don't fall for that sovereign citizen nonsense. Don't be those guys. Don't be a sovereign citizen. How about that? Because it's an oxymoron. You must decide who and what you are. Don't be a moron. Don't be a sovereign king slave. Don't be a king slave, a king state slave. All right? Don't be that. But understand your status, determine your status, and whether you are a slave or just a sovereign. Cut that out. Let's erase all that. You're sovereign, or you're a sovereign. Okay. All right. Now that's it for the zip code. Very short article because tons of information, crucial information, honestly. Now, a guide comparing the affidavit. This answers some quick questions about affidavits. What is their purpose? Why do you have to write one? What goes in one? Right? What goes in an affidavit? All right, let's start. What's an affidavit? We use affidavits to present evidence to the court. Sometimes courts hear evidence from witnesses who give their evidence in person, right? That's considered an affidavit in and of itself. We don't call it that. We call it witness, right? We go through the process of having a witness through trial. However, for certain court cases, you must present your evidence by affidavits. A lawyer can tell you if your case requires an affidavit. An affidavit is a written statement that contains important facts you want the judge or the master to know about. You swear it under an oath. Now, first things first, we don't swear. No, we don't swear. Not over here. We don't swear over here. So instead of swearing an oath, you affirm. You affirm. What does affirm mean? To affirm money is to give it a big yes or to confirm that it is true. To answer positively. Okay. Now, is there a difference between affirm or Swear an oath, right? Right? What is the difference? The swear is traditional. The affirm variant is there for those who may have objections, religious or other, to swearing. Keep that in mind, y'all. Keep that in mind. Swearing under an oath before a registry clerk, or a lawyer. To swear means you promise that the information contained in the affidavit is true. Same thing for affirm. The affidavit may have letters or other important documents attached to it. These are often referred to as exhibits to the affidavit. The affidavit is filed in the court registry. Copies of the affidavit have to be given to the other persons named in the lawsuit. Right? The first rule about preparing an affidavit is that you should tell the truth in your affidavit. In the Supreme Court of British Columbia, there was a form you must fill out in your affidavit. This is a sample affidavit at the end of this guide. So what's in this guide? You'll get a general idea of what you put in affidavits. You will review the structure, find out how to fill in the technical parts, find out how to fill out the main part. It'll give you where to get legal advice, questions to ask the lawyer, checklist, and a sample. You have a sample of a completed affidavit. All right, if you're doing it yourself, get some legal advice. This is the same thing for us, y'all. You don't have to go to a lawyer to handle your affairs, but you can have consultations with professional law professionals who are here to provide their expertise. And if you ask the right questions, you'll be surprised with some of the answers you'll get from these folks. If you are going to represent yourself, get some advice from a lawyer, right? In resource B, we can bring you questions you can take to a lawyer. All right, so this is the express lane. If you are pressed for time, use the express lane. Here's what you do. Read sections 2, 3, and 4 of this guide. That's what we're going to do. We're on the express lane. Make an appointment with the lawyer. Ask the lawyer what you need to put. Ask the lawyer to fill out the front page. Follow section. We're not going to use the lawyer. Everything but the lawyer, we're going to follow this. So let's go to sections 2, 3, and 4. All right, this is what goes in. We just talked about that. So what's the structure of an affidavit? You have a sample affidavit in the resources. An affidavit has 7 parts. Okay? The style of proceeding. Deponent statement. Deponent is the person making the affidavit, right? Your statement. Knowledge statement, right? This is general knowledge. Body of the affidavit. This is the most important part. You have the ending, the exhibits, and the backing sheet. Most parts of the affidavit are technical. Section 3 explains how to fill them out. The body of the affidavit is where you explain your story to the judge. Follow the steps in section 4. So let's keep going. Let's go to section 3 so we can find out how to fill in the technical parts. The style of proceeding, all right, appears on the first page of all court documents, all right? So let's go to we have a sample one on the bottom here. Let's check out the sample affidavit, right? This is the sample affidavit. All right, so you have the sample, first initial, last name, date, number for the registry, between blank, this is the plaintiff, the petitioner, defendant, respondents, affidavit of blank, I blank of blank in the city of blank. In the province of British Columbia, solemnly affirm and say that I am the blank of this in this matter, and as such have personal knowledge of the matters herein referred to. Or I am blank in this matter and have personal knowledge of the blank facts and matters referred to by me, except where indicated to be on information and belief, and where so stated, I verily believe them to be true. All right, so let's go back. Section 3. We started off with the style of proceeding. In the top right-hand corner, the style of proceeding, you must write your initial and surname, the number of the affidavit, the date on which you made the affidavit. Here's an example. M. Smith, number 3, June 1st, 2004. This goes in the right-hand corner so the judge can easily identify the affidavit. The number 3 indicates it is the third affidavit sworn by Mary Smith. You need to swear the affidavit. This means you swear under oath to God, or you affirm that you are telling the truth in the affidavit. You do one or the other, not both. Cross out the one that does not apply to you. On the form, you may see a part that deals with interpreters. If you speak English, cross all this out. It does not apply to you. A deponent is the person who is making the affidavit. This is your statement. You have to identify yourself as the person who is making the statements in the affidavit. Here's an example. I, Tom Jones, electrician of 132 Main Street in the city of Vancouver, province of British Columbia, make oath and say that This deponent statement has to be put at the beginning of each affidavit. It identifies who you are and what your occupation is. If you're retired, we put in retired or old age pensioner. Now, for nationals, for indigenous aboriginals, right? We need to understand that we have to use all our collective information that we know about commerce. All right, we know that commerce is intercourse. All right, commerce is intercourse. Correct? Let's check out commerce. This is all a commerce game, guys. This is all a commerce game. You got to understand commerce if you're going to be able to understand our law systems. It's the activity of buying and selling, but it's deeper than that. It goes deeper. Intercourse by way of trade and traffic. All right. You have commerce is a term of the largest import. Commerce is a term of the largest import. It comprehends intercourse for the purposes of trade in any and all forms, including transportation, purchase, sale, exchange of commodities between the citizens of our countries and the citizens or subjects of other countries, and between the citizens of different states. The power to regulate it embraces all the instruments by which such commerce may be conducted. Commerce is not limited to exchange of commodities alone, but includes intercourse with foreign nations, right? Commerce and trade are similar but not identical, all right? Selling, the buying, selling, and exchanging. Commerce, dealings, or political communities. So it's when you're dealing with other people, when you're dealing with others. This is what you're doing when you're doing commerce. All right? That's what you're doing here in this affidavit. You're dealing with another party. These are dealings with another party. This is commerce. You have to understand that. And also, you have to understand that what you identify yourself as, they will hold you to that. But you have to know who you are. This is about knowing your history. This is where knowing your history is extremely important. If you don't know who you are, how do you know who is making the statements in the affidavit if you don't know who you are? Let's continue. The knowledge statement does two things. The next part is the knowledge statement. You state whether you are the plaintiff, defendant, petitioner, or respondent. You state that you have personal knowledge of the information and facts that you are putting in the affidavit. All right, here's an example of what you would put in. I am the plaintiff in this matter and have personal knowledge of the matters herein referred to. An affidavit should not contain information told by another person unless the other person is a party to the court case. The rule about having personal knowledge will not apply if the judge is being asked to make a temporary order. You can, in these situations, you can make an affidavit based on information and belief. All right, information and belief. Now we don't want to use our personal knowledge. We want to use, we want to make an affidavit based on public information. Right? We want to make public information. This is universal public information. All right. It talks a little about you have to indicate the specific person you're relying on for their information and belief. So, all right. I have personal knowledge of the facts and matters herein referred to by me, except where indicated to be on information and belief, and where so stated I verily believe them to be true. You have to indicate the specific person you're relying on for the information and belief. You also have to add a statement to the effect that you believe it to be true. All right. Now, body of the affidavit. This is the most important part. It's covered in section 4. We'll get that to in a moment. In the ending, you must swear in front of a lawyer or a commissioner for taking affidavits. You both sign the affidavit in each other's presence at the time you swear it or promise you are telling the truth. It is a serious offense to make a false or misleading affidavit. Right, the lawyer or court official must also print his or her name below his or her signature. Check to see if they have printed their name. Ink stamps bearing the name of the lawyer or court official are acceptable. You may attach letters or other important documents you want the judge to consider. These are exhibits to the affidavit. You know, if you ever hear people talk about when you send in the affidavits, they want you to attach certain documents. These are considered exhibits. Here is an example of what you can say in the body of the affidavit. Letter as exhibit. On July 30th, 2004, I received by mail a letter from Mary Smith. The letter is attached to this affidavit as Exhibit A. Okay? So let's go to section 4. Oh, excuse me. We're not finished with this part yet. Each page of the exhibits has to be numbered consecutively. If you have exhibits A to G totaling 40 pages, yes, folks, you're going to have affidavits with attachments of up to 40 pages worth of documents. All right? Get over it. You need to do your due diligence and make sure that your documentation backs up the facts that you are trying to prove to the courts. All right? A lot of people are running into problems because they don't know how to back up their claims. All right? Be specific. Be complete. Cover everything. Cover it even if you don't think you have to cover it. If you have exhibits A to G totaling 40 pages, one exhibit may contain 2 pages and another 8 pages. You start numbering with exhibit A at page 1 and you finish with exhibit G at page 40. You print in the number for each page of the exhibits. Most law firms have stamps that you can put on the documents. Exhibit stamps go on the first page of each document and they read as follows. This is exhibit blank referred to in the affidavit of blank sworn before me at blank, this blank, day of blank, 2000 blank. All right. Do not put a stamp on the documents until you've run things first by a lawyer or a professional advisor. It may be necessary to add or delete documents. Now you have a backing sheet. This document is attached to the back of all court documents. All right. The backing sheet consists of 3 parts. You got to have this if you're making an affidavit, the backing sheet. The first part is the style of proceedings that we have already described. The second part is a description of the document set between 2 lines. In the third part, you put in your name, address, and phone number. Also put in your fax number and email address if you have these. A backing sheet helps the court staff to file the document in the correct court file. A backing sheet is not a necessity. Registry staff will let you file your affidavit without a backing sheet. However, a backing sheet is considered more professional. I think we need to follow the more professional route. I like to be, I don't know about y'all, but I like to cover my bases. If something as important as this, next, find out how to fill out the main part. You have to follow the SOS principle. All right, what is the SOS principle? Simple, organized, short. Try to make your affidavit as simple as possible. Use simple words and sentences. Many people think that if they make things complicated and sophisticated, they will impress the judge. The judge will see through this. Judges are more impressed with a simple affidavit. Also, a simple affidavit is easier for you to prepare and to present to the court. Remember, judges prefer people to use ordinary language. Right? It's very interesting that a lot of people, they like to use the signature. When they use their signature, they write their autograph. They like to use the term all rights reserved. Right? UCC 1-308, all rights reserved. But I've had plenty of people also who run into a nice little ploy used by the judge where they simply ask, what do they mean when they say you reserve your rights? What are you talking about? Explain yourself. Elaborate. Most people can't explain what they're doing. All right? Stop trying to be fancy. Break it down. Break everything that you're writing in your affidavit. Break it down to the lowest denominator, Make it so that anybody, a monkey, can read it and they understand it. All right. If you have a rule or you put it in UCC codes or you put it in certain Supreme Court laws, define those Supreme Court case laws. Make sure that you're explaining those UCC codes and defining them specifically. Next part, organize. The second principle is that your affidavit should be organized. This is the most important rule. If your affidavit is organized, it is easier for the judge to understand what is going on. Here are some tips for being organized. In most cases, it is best to tell what happened in chronological order. Do not jump all over the place from one time period to another. Tell your story in a straight line. Get your story straight, folks. The one thing that really disappoints me is that people do not have their history straight. They can't define who they are through the history. They can't go into the history books, point at a civilization, and show how they are connected to it from today going back. They can't make that connection because they don't know the history. All right? It's so important that you know your facts and that you're organized and you can say it in a straight line. It's so important. So important, guys. That before you try any of this stuff, that's what you need to do. You need to make sure that you're straight on your history, you're straight on who you are. That way you can write it. All right? When you refer to people, it's best to use their names, such as John Smith. Try to avoid using him or her. It can get confusing. You can organize your affidavit in a different way, depending on the nature of the case. Yada, yada, yada. Next is short. You want to be simple, organized, and short. The third principle is to keep your affidavit short. Short is more effective. First decide what is necessary to put in your affidavit. Put that in the affidavit. Don't fall into the trap that more means better. It doesn't. The same is true of paragraphs and sentences. Keep them short. Sentences should be less than 10 words. If you can make sentences shorter, then do it. All right. Edit your affidavit and break up the long sentences into short sentences. This does not mean you ignore important matters. However, if your affidavit is short, it allows both you and the judge to focus on the important matters. So the judge wants you to focus on what's important. Okay? You tell them all this. A lot of people, they go and they get set back frivolous. Frivolous. It's all frivolous to them because you're talking about a bunch of stuff. They want to focus on the important shit, the shit that actually matters and the shit that they actually affect. All right? So what are the relevant facts? It should contain relevant facts. Usually it's best to draft an affidavit in the first person. All right? Here are some useful tips. Affidavit should be done on white paper. The font size and spacing should be the same as the sample affidavit. Consider putting headings to make it easier to organize. Each page should be numbered. Each paragraph should be numbered. If at all possible, type the affidavit. Although in theory, you can provide a handwritten affidavit. Try to avoid it. Don't listen to that. In many cases, I know people who wrote affidavits on napkins and they were able to put it into the court. So, take that as you may. Affidavits should avoid vague statements. Here's an example of a vague statement. I met the defendant contractor John Smith on several occasions. I walked away from these meetings with the impression that he would not charge me for the extra paint put on the porch. Very vague. Here's a much better statement. I had a meeting with the defendant on April 3rd, 2004 at my home in the late afternoon. He specifically stated to me, quote, I will not charge you for the extra paint on the porch, end quote. I relied on this statement that he would not charge me for this extra paint. Next, take your time. Draft the affidavit over several days to give yourself enough time to think about what needs to be done. It's not a good idea to draft an affidavit in a hurry. That won't give you the time you need to think about it. A lot of people, they just get templates off the internet and they send that in as if that's their affidavit. That's not your truth. That's not your truth. Take your time. This took some people their whole lifetime to figure out. You think you're just going to steal a template from online and think you're going to be able to flip it and then just be free? Study, y'all. Use the checklist. Use this checklist to make sure you have completed. The checklist is in resource C. You have checked for consistency. Read it over. Have a friend check it. Right? Again, I know we're dealing with people who, when they went to school, they obviously didn't care about their education in many respects. You know what I'm saying? I know a lot of people didn't care about high school like that, but they did teach us one thing. They taught us how to be professional, how to carry things in a professional style. All right? You have to have people edit and check your work. Pass it around. Proofread it. All right? They may see something that you don't. All right? It's so important. But again, people you trust, you just don't want to give your stuff to anybody. All right, what do judges look for? Judges assess credibility on an affidavit based on the following factors. Are there internal inconsistencies? So that's the first thing they're looking for. They're looking for, all right, this guy gave me an affidavit. What are some inconsistencies I can find here? What's inconsistent in here? All right, are statements made in the affidavit inconsistent with other statements made in other affidavits or documents outside the affidavit? In a rush, you may carelessly make statements in an affidavit that are at odds with your other affidavits or documents. This could hurt your case. You should have a file of everything you've documented. Everything. You need to have documented the actions you've taken with all of your documentation. Gotta write it down, man. They're not playing. You don't need to play neither. If the statement inherently unbelievable, don't say nothing that people look at it like, this nigga's crazy. You have to word it correctly. Word it in a way that it will be effective. Is the person biased in making the affidavits? Do the statements in the affidavit show an obvious bias? All right? Now, as you know what I'm saying? We know that we're biased when we're talking about our personal stuff, but we know that because there are inconsistencies in the government, they want you to perceive these things. Remember, this is a document based in Canada, the corporation known as Canada. Just like the United States is a corporate entity. They want us to follow the same process we've been doing. So don't get, you see this, is a person biased or you're biased, you know what I'm saying? Speak your truth, brother. You know your truth. All right. The additional factors. Remember, judges like to see facts, not broad general statements. They like to see facts. We'll give them facts now. We can give them some facts. All right. Don't be evasive. All right. Let's see. You should avoid. Okay. In other words, does a person making the affidavit attempt to avoid an issue or statement? Don't try to avoid anything. If they're talking about an issue or something, make sure that you don't try to avoid it. Try to not try not to dance around certain facts that you've already already attempted to prove. If the person used language that one would not expect a normal person to use, judges prefer people use their ordinary language, right? Your ordinary language. But we know as nationals, as indigenous aboriginals, our natural ordinary language is something that he'd never understand anyway. Is the second best evidence used instead of the first source. Don't show evidence from a secondary source. Always show it on the first positive, most primary source. Right? Find the original information. Find the original information. Is there a lack of precision in the affidavit? Does the person make the affidavit use imprecise dates or imprecise information? They're going to check you. Are there mistakes that indicate the person making the affidavit has not read it? This would include typing and grammatical errors. So all y'all copy and pasters, they going to see it. Are important facts left out? It may look like you're hiding something. So let's look at the resource. Let's see. Useful tips about seeing a lawyer. Bring a friend with you. Questions to ask a lawyer. What is the style of proceeding? All right. All right. So here's some basic questions. You should ask any law professional before they help you about your case, before, you're talking about your case. You should ask them, what is the style of the proceeding? What are the important facts that I should put in my affidavit? In what order should I organize my affidavit? Who should I get an affidavit from? Can this affidavit be based on information and belief? Should documents be attached to the affidavit as exhibits? If so, which documents should be attached? When does this affidavit have to be filed in court? What do I have to give copies to? Who do I have to give copy to? And what is the time limit for doing this? These are the main questions you should be asking your law professionals when talking affidavits. Again, you'll be surprised from the answers you'll get. Right? Remember these questions, y'all. Questions to ask a lawyer or a law professional. I'm not a big fan of lawyers and attorneys. I say ask a law professional. Maybe preferably somebody who teaches law. Maybe not a lawyer. All right, checklists. These are just things that you can do. Have you put in exact dates, some checklists. So here's the sample again. All right. As you see here, this is the sample. You have the first page, your cover sheet, sample affidavit, you have the plaintiff, defendant. All right. This is your swear, you're affirming, sworn before me at the city of blank of Vancouver, commissioner for taking affidavits. The Supreme Court of British Columbia re Judicial Review Procedure Act, Employment and Assistance Act between Mary Smith and Appeal Tribunal, Minister of Human Resources. I, Mary Smith. All right, so remember up here, in the Supreme Court of British Columbia. All right, this is a response. Re is a response. All right, she is referring to the Judicial Review Procedure Act, the Employment and Assistance Act, and Employment and Assistance for Persons with Disabilities Act. All right, she's showing how Mary Smith, notice the all caps. All right, and this is Employment and Assistance Appeal Tribunal, Minister of Human Resources. Okay, this is the respondents. This is the petitioner and the respondent. Remember, this is the petition. Okay, I, Mary Smith, welfare recipient of 124 Mary Street. All right, in the city of Vancouver, in the province of British Columbia. She doesn't make an oath. She solemnly affirms and says that I am the petitioner in this matter and have personal knowledge of the matters. I'm 46, been on welfare since 99. I have 3 disabilities, which are diabetes, depression, and a back injury. Application for disability benefits. I sent in an application. A copy of that application is attached. On March 26th, I received a letter for your disability benefits was turned down. So this is a lady. She's 46. And she's been on welfare since 99. She went in 03. She sent an application, right, to get disability allowance. All right. She filled it out with herself and her doctor. She attached that exhibit to the affidavit as proof, as evidence. Right. In 2003, she received a letter in March 26th, from the Ministry of Human Resources. Right. And remember, the Ministry of Human Resources is who she's sending the affidavit to, or she's referring to in the affidavit. All right. It was turned down. Her application was turned down. All right. A copy of that letter stating that her application was turned down is in evidence. Exhibit B. Save your paperwork, y'all. Don't get this paperwork and just throw it out or just try to hide it. Save that joint. File that shit. Keep that shit for your records. All right. And combat it point for point. On about March 10th, I filed an application for reconsideration. Exhibit C. Along with the request, I attached a letter from my doctor. Exhibit D. The ministry was received by me. This reconsideration turned my appeal down. This is Exhibit E. On March 19th, I sent an appeal to the Employment and Assistance Appeal Tribunal. A copy of that appeal is F. They convened to hear my appeal, which I attended. The hearing started and I introduced my advocate who was going to represent me at the hearing. The chairperson refused to let John Jones be my advocate on the grounds he was not a lawyer and ordered Mr. Jones out of the hearing room. It was important for my case that Mr. Jones be present to represent me. On the same day, they issued a decision. A copy of that decision was Exhibit G. I lost my appeal. That was her affidavit. Right? This is the backing sheet. All right, this is just a recurrence of what happened before, so it's easy access, right? So again, and that's the end of the sample. For you guys, I didn't know. Simple. This affidavit. This is just stating the facts. Right? She is obviously seeking some type of redress, right? She wants some type of remedy, right? She wants another party to hear this, okay? All right, y'all. That was just some quick stuff about affidavits, all right? Understand that you will write affidavits for many different things, but it's up to you to write your truth out in an affidavit. And through those affidavits, you will be able to prove who you are, not only who you are, but explain who you are. You know, I feel like a lot of people, they always have this problem that they're misunderstood, or that people don't want to know who they truly are, or they're preventing them from showing who they really are. No, it's you who haven't written it out. Right? Write your affidavits out, y'all. This is a guide to preparing your affidavit. All right, y'all. Y'all can check it out. If you need to, you can always check a brother out on Facebook. V Kid Pursuit of Enlightenment, or Vinny the Moor on Facebook. Or you can also check out the squad, the original Moorish American Israelite Study Squad, ATL. I always do crucial breakdowns. I always try to bring more information. We have files in the group, plenty of files, so you can have more than enough reading for you. You know what I'm saying? Like, I hope that as many people as possible can read this stuff. I mean, it's free. It's out here for free. I'm giving it to y'all for nothing. You know, I just want y'all to learn, honestly. All right. Now, lastly, that was the end to a guide to preparing an affidavit. Now, lastly, I have legal fiction. This is Legal Fiction by Lon L. Fuller. And I had a little section I wanted to just delve into right quick. This is about the form of the fiction, assertive and assumptive fictions. Gray said that the fictions of the English common law were more brutal than those of the Roman law. By this, he did not mean that the English fictions did more violence to the truth than those of the Roman law. The Roman fictions were not lacking in a certain audacity or brutality in that respect. He referred to the form of the fiction. Fictions have played an important part in the administration of the law in England. It is characteristic of the two peoples that the use of fictions in England was bolder, and if one may say so, more brutal in England than it was in Rome. Thus, for instance, in Rome, the fiction that a foreigner was to be considered as a citizen was applied in this way. It was not directly alleged that the foreigner was a citizen, but the mandate by the praetor to the judge who tried the case was put in the following form. If, in case Aulus had been a Roman citizen, such a judgment ought to have been rendered. Then render such a judgment. In England, the plaintiff alleged a fact which was false, and the courts did not allow the defendant to contradict it. The Roman fiction, in other words, carried a grammatical acknowledgement of its falsity. The English fiction appeared as a statement of fact. Its fictitious character was apparent only to the initiate. The Roman fiction was an assumptive fiction, a fiction taking an as if form. The English fiction was and is a fiction ordinarily taking an is or assertive form. So what are they saying here? They're talking how in Roman law, legal fictions were made in a metaphoric, as if form. English fictions turned into an assertive is form. Okay? It is that. That's what that is. Instead of as if. It might seem at first glance that we're dealing here with something very fundamental. Indeed, it might be argued that an assumptive fiction and as if fiction is not a fiction at all. All right. If a court only says that it is dealing with A as if it were B, it has stated nothing contrary to the fact. Yet a closer examination will show that the distinction is one of form merely. The supposing that or as if construction in the assumptive fiction only constitutes a grammatical concession of that which is known anyway, namely that the statement is false. When we are dealing with statements that are known to be false, it is a matter of indifference whether the author adopts a grammatical construction that concedes this falsity or makes a statement in the form of a statement of fact. Listen to that again. You have to hear what they're talking. This is legal fictions. What is a legal fiction? All right? When we are dealing with statements that are known to be false, think about all the statements that are known to be false. You are a U.S. citizen. This is a democracy. It is a matter of indifference whether the author adopts a grammatical construction that concedes this falsity or makes a statement in the form of a statement of fact. So that means you can go ahead and keep talking like it's the goddamn truth, knowing it's the goddamn lie. The peculiar force that the fiction has in rendering easier alterations in the law by appeasing the longing for an appearance of conservatism seems not to be lost by closing it in the as-if form. The Roman praetor apparently felt that by framing his innovations in terms of older rules, he had secured some justification for them, even though the pretenses involved carried on their face the acknowledgement of their falsity. Gray apparently saw in this difference in the form of the fiction in Rome and in England some expression of a fundamental contrast in the characteristics of the two peoples. It seems likely, however, that there is a more prosaic explanation for the difference. The dissimilarity of the modes of the trial and the two systems of law seems adequate to explain the diversity in the form of the fiction. Now, real quick, legal institutions as fictions, though the most essential ideas are nearly all, if not all, fictitious. Marriage is a fictitious purchase and sale. The power of a father is a fictitious master's power. Adoption is a fictitious fatherhood. In certain respects, the last will and testament is, at least sometimes is, a fictitious adoption. Legitimation assumes fictitiously a marriage which never existed, etc. It would not, therefore, be inaccurate to claim that our reality is simply fiction differentiated, and that bottom all law is reduced to a series of fictions heaped one upon another in successive layers. That's it for tonight, folks. I feel like I've I've said a lot. Read this book, Legal Fictions by Lon L. Fuller. You'll see the deceit, how it's written in plain language, right? Y'all know I'm gonna dropping it all on the original Moorish American Israelite Study Squad page. All right. You can always, if you need to, hit me up on Facebook. You can also hit me up on the tube. I am also on the tube. Vinny the More, guys. Vinny the More at Gmail. You can email me. Email me. You got questions? Email me. Right? I got my little library of information. I got my subscriptions. I got my page as well. All right, we got videos here. I got some of my podcasts. I got other crucial breakdowns. I'm gonna put this breakdown up as soon as I can for y'all. All right, I am Vinny L, and I'm signing off. I feel like I've covered a lot today. All right, income tax is voluntary. Zip code use invokes federal jurisdiction. A guide to preparing your affidavit, and legal fictions by Lon L. Fuller. All right. Again, I'm Vinny L. Y'all follow, like, comment, subscribe. Follow me on Instagram at IGVKID_. Check me out on Facebook. Y'all spread the word. Share this information with somebody. You know what I'm saying? Get them to know something that they didn't know yesterday. This information needs to be public. We all need to know this information at this point. All right, too many people have come before us and dropped this information with us just listening and laughing and smacking on a Popeye sandwich. All right, y'all, peace and love, y'all. We'll do this again soon. Peace.